Right, hi, welcome back, Attorney Steve Vondran. Welcome to another exciting episode of Litigation Whiteboard. All right, today we're talking about AI and copyright law. Without further ado, let's head to the Attorney Steve Litigation Whiteboard. Boom. All right. So we're talking about this new case out of the District of Delaware, the Delaware District Court. This is a case that was testing AI. We've kept our eyes on this as copyright lawyers here. So here we have the case. It's dealing with Westlaw and Ross Intelligence. Okay, so Westlaw, I'm in the legal business. Westlaw is a legal research engine. I used to use that a lot. I'm now a big fan of Lexis, a lot of tools. I like Lexis, but I used to be a Westlaw user. Westlaw is owned by Thomson Reuters. And so Westlaw has all these different kinds of tools. You can get pleadings, you can get documents, you can get checklists, legal guides, all kinds of stuff. One of the things that they have is called head notes. And I'm going to show you right up here what a head note looks like, okay? So these are considered copyrightable as part of their copyrighted content because they are considered editorial in nature. So their staff at Thomson Westlaw, they are analyzing the cases. They're creating this head note system. And Lexis has its own little version of that, but they're basically trying to make law simpler to find, research, and then to research similar topics under that particular head note. So in this case, we had Ross Intelligence, a competing legal research engine. They wanted to get in there and compete and mix it up and rumble. Why? Because these guys make gobs of money selling data and content and analysis and guides and things like that. So they make a ton of money selling data. Folks, you're a young kid, find a way to sell data, let me tell you. All right. So Ross was competing. They reached out to Westlaw and say, hey, can we get a license? Can we buy a license to your content? And Thomson Reuters Westlaw said, I don't think so. You're competing. Why would we do that? We're not going to help you be a competitor of ours. Doesn't make sense. So anyway, so Ross then comes to this other company. Let's just call them Legalese. Legalese is a company where lawyers would answer legal questions based on these head notes. Okay, so we have Westlaw head notes and annotations, things like this that are considered copyright protected. It's a very low margin of copyright originality to obtain that protection. And so the courts are finding that, yes, that is indeed copyrightable. So if you copy it, if you're copying these head notes or their annotations and whatnot, you can be deemed infringing on their copyright. So that's what happened here. So they go to Legalese and say, hey, can you create these bulk memos based on their head notes and to help us train our AI product? So they were creating a non-generative AI search tool. And so Legalese says, yeah, we can help you out. We can get this figured out here. So they had all these bulk memos with using their head notes as guides for question and answers. And the court found that there was 2,234 different head notes at issue. And so Thomson Westlaw just said, hey, you're using this. These memos are substantially similar to our copyrighted content. And that is copyright infringement. So you owe us money. So they moved for summary judgment. The court granted partial summary judgment. Okay. In making this determination, they found that there was no fair use. Ross tried to say, hey, this is just a fair use. We're just going here and we're making some creative product of our own using some head notes. You know, maybe they're not even copyrighted head notes. We're benefiting the public. The public's going to get some access to some great information, legal information. They even argued this is innocent infringement. They even argued this was a copyright misuse or scenes affair. So there was all kinds of defenses. Bottom line, court didn't like it. Court looked at the fair use factors. As you know, if you've watched my other videos, there are 4 fair use factors. The 2 that are usually considered the most important are the first, which is the nature and character of the use, whether you transformed the original content into something new and whether there was a commercial purpose. And the 4th factor of whether or not the defendant's use is a commercial competing use what we call a market substitute. The court said, yeah, no, there's no transformation. As to the first factor, there's no transformation going on. And as to the fourth factor, this is a market substitute. So fair use did not work out here. We'll keep an eye if it works out on the generative AI tools. This was non-generative once again. We'll talk about that in other videos. But the court basically found in favor of the plaintiff on applying the four fair use factors. And there you have it. So that's it. We're going to keep an eye on these cases. AI, if you need help, be very careful. You need to, when you're copying other people for your language learning tools, your language learning models, you need to make sure you either have a very strong fair use defense, as they did here in Ross. They did try to get the license, which was refused. So they did try to take the proper steps. But if you don't get the license, you need to make very sure, very clear that you do have the rights to do what you're proceeding on. Otherwise, you do all this work, you invest all this money, you may get investor money, all for naught. What fun is that? And I'm not sure the current status of Ross Intelligence, but they may not be doing too well. I don't know. Do your own research. At any rate, this is general legal information only, not legal advice. AI and copyright law with Attorney Steve. Thanks for watching, you guys. Have a great Wednesday. We'll be back with more great information. Don't forget to subscribe.